Hi everyone, so if you have not seen my previous videos, I did summarizations of the Idaho 4 Moscow murders motion in limine hearing that happened on April 9th. And I went motion by motion and summarized what the judge had said in court and if he was going to reserve his opinion for a later date. He has now announced his official opinions, and so I wanted to go one by one with them with you. So for the motion that Brian put forth for the inflammatory evidence, Hippler, the judge, said that at this point the defendant has not identified what specific evidence he wants kept out or otherwise defined exceptionally inflammatory. Issuing an order as requested by the defendant would lack any substance. It would simply require the state to abide by evidentiary rules and prosecutorial responsibilities when presenting its case. The court finds this unnecessary and therefore denies the motion. The second one he ruled on was regarding now these were all ruled on within court, so I probably already touched upon them in my other videos. I'm just going to go over them, but there's also other ones that he just issued rulings for today that we will go over. So now this is regarding the use of the term murder. He says that it's unnecessary, and the state acknowledges it would be improper to refer to the defendant as the murderer other than stating what the allegations are, and has no plans to do so, otherwise elicit similar testimony from witnesses. Thus, the motion is denied as unnecessary. Now, regarding the words psychopath and sociopath being able to be used against Brian, he said, the state does not intend to use these terms at trial. Indeed, the terms are irrelevant given the lack of evidence defendant has been diagnosed with a personality disorder or similar mental illness. Their use would be also highly prejudicial. Thus, the state is not to use these terms or their equivalents at the guilt phase of trial. If, however, the state believes the door has been opened to allow the use of such terms, it shall raise the matter in advance outside the presence of the jury. The motion is granted. So the state came back and said, just like Brian's wanting the terms murder, psychopath, and sociopath to not be used, the state didn't want the defense using terminology like, oh, the state is trying to kill Brian. And so therefore the court also denied their motion because he believes on both sides of the aisle they should be able to conduct themselves professionally and not use that terminology. And so therefore that motion from the state was denied, stating it was not necessary. So now we're moving into the motion of unnoticed 404B evidence, or i.e. the traffic stop that Brian had on August 21st, 2022, and this was prior to the murders with Deputy Duke, or was it Corporal Duke? Anyway, but he was alleging that the state is also going to bring up his DeSales paper where it can prove that he knows how to clean up a crime scene, and then his Amazon purchases against him. But the judge said those are not qualifying for 404B evidence because it does not prove a prior bad act. Buying something online or writing a paper are not bad acts, so they don't follow underneath that category. Therefore, the judge states the defendant's Amazon purchases in his graduate paper discussing proper crime scene investigation techniques do not, standing alone, bear on his character or suggest he has a propensity to commit crimes, including those he has been charged with. Further, the court is unwilling at this point to preclude the state from filing 404B evidence in the future if it determines its evidence is encompassed by the rule. There are still 4 months until trial begins, well within the reasonably in advance of trial time frame required by the rule. The state acknowledges its notice obligations under the rule and intends to comply with the rule with regard to any proposed 404B evidence. The timeliness of such future notice will be analyzed if and when such notice is given, and objections can be advanced at that time. The motion is therefore denied. Now the next ones are kind of encompassing 3 different ones together, but it's defendant's number 10 regarding the improper expert testimony of middlemen, the defendant's motion for excluding IgG evidence, and then the state's motion for investigative genetic genealogy that he touches upon in this one. So pretty much sums it up right here. It says both parties move to exclude evidence of law enforcement's investigative genetic genealogy, or IgG testing in this case, but for entirely different reasons. Given the parties' agreement to not present any IgG evidence, those reasons need not be discussed given the bottom line agreement, and the court grants the motion. The state has indicated it will present evidence through Detective Brett Payne. The defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutually agreeable narrative about how the tip came about. The parties are also directed to jointly craft a jury instruction advising the jurors to not concern themselves with the source or nature of the tip. Now, personally, I don't know why they're agreeing to that, because I want to know, as the public, where did they get this tip and who from and how? But whatever. So the next one that he touched upon was the defendant's motion for conditions as an aggravator, meaning not being able to use his ASD or autism spectrum disorder as a reason to apply the death penalty in the penalty phase of the trial. Now, the state responds that it has no plans to use such evidence as an aggravating factor in light of the Zant versus Stevens case that was ruled upon, but it will argue against and rebut defendant's diagnosis to the extent he relies upon it as a mitigating factor. So I'm just going to read this paragraph because it's just easier than me having to try to summarize it. So it says, despite the state's concession, the court is concerned with the breadth of defendant's motion. He is not only seeking to preclude the state from referencing his ASD diagnosis as an aggravator, but any symptom of his ASD. Given the broad nature of ASD symptoms, the court foresees an issue potentially arising at trial whereby the state makes reference to an action taken by defendant that defendant contends is a symptom of his ASD. That evidence is not currently before the court. Thus, at this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on grounds that it evidences a symptom of the defendant's ASD. The motion is therefore granted in part only. As far as the state's motion for the alternative perpetrator evidence, the state seeks an order prohibiting defendant from offering an alternative perpetrator evidence without first making a showing that such evidence is relevant and admissible under the IRE 401 and IRE 403. And basically says the defendant acknowledges his burden under Meester, but argues that the state's motion is premature. According to defendant, this case is full of alternate perpetrators. There's a video on my YouTube where I couldn't discount a lot of people in this case, and I'm sure there's more that we don't even know about. So, that being said, he intends to produce offers of proof as to alternate perpetrators. While defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof laying foundation for the admission of the evidence will likely take a significant amount of time. After all, defendant cannot merely show another person could have committed the crime, rather there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. To avoid undue delay at trial, defendant must present the offers of proof no later than May 14th, so the matter can be addressed at the pretrial conference. The court will reserve ruling on this motion. So we're kind of halfway through, and these were all the things that were touched upon in the hearing that he pretty much kind of ruled on the spot, but they're just kind of putting them in a written format. And then there's new ones that I want to get to, so make sure you hit that follow button and follow along with me, because this is only part 1.